Reference to or information about any specific product or service by name, trademark, or service mark in this podcast does not constitute an endorsement of that product or service. In addition, during this podcast, legal examples will be discussed. This podcast is for informational purposes only and should not be considered legal advice. We are not responsible for any losses, damages, or liabilities that may arise from the use of this podcast. Please consult a licensed attorney regarding your own situation and prior to making any decisions. And now on to the episode. Hello, and welcome to Better Money with Elements Financial. I'm your host, Miranda Finley. I'm a certified financial wellness professional who has worked with thousands of people in all walks of life, and I'm also a real person with real financial experiences. I'll chat from both personal and professional viewpoints to help make your money better. We'll be guiding you through the basics of estate planning today. We understand that estate planning can feel very sensitive and uncomfortable for many of us, and thinking about what will happen to our assets and our loved ones after we're gone is a daunting task that can be overwhelming. However, facing these realities head on and planning ahead to provide immense peace of mind and security for you and your family is what we're shooting for. Today, we're going to guide you through that process with empathy and understanding so that you can feel empowered to make informed decisions about your estate. And here to help me do so is Ken Emswiller of Emswiller, Williams, Noland Clarke, LLC. He has been a licensed attorney in the state of Indiana, specializing primarily in estate planning, serving clients in Indianapolis for over 40 years. Ken has been the preferred estate law attorney partner of Elements for many years. Of those 40, he's been practicing. Thank you so much for joining us, Kent.
Thanks, Miranda. I'm glad to be here.
Yeah, we're very glad to have you. I always learn something every time I hear from you, so I'm excited to hear what you have in store for our listeners today. So I want to start with the basics. What is an estate plan? What do we need to know about it?
Well, without having to use the word plan again, it's an organized attempt to make sure that your assets go to the people that you want them to go to in a simple, cost-effective manner without having to increase the legal entanglements required to do that.
Okay. And I mean, obviously, we feel that estate planning is pretty important in the banking world. And what do you feel like the importance of estate planning is? What does it represent for people?
Well, it has a couple of things it represents. First of all, no one gets off this planet alive. So that's the first thing everybody out here has to understand is that there will come a time when you're not taking any assets with you to the cemetery. There's no Brinks truck in the procession going out there. So given that piece of information, it's important for everybody to recognize that there will come a time when their estate plan, organized or unorganized, will be put into operation, and that will occur. And it either can be simple for those you leave behind, or it can be difficult.
Yeah, absolutely. You know, you said there will come a time when this needs to come into play. When is that timing, and when is it right for people to start thinking about an estate plan?
Well, I get that question a lot, and I tell young married couples that if they're wanting to leave everything to each other, they probably need a very, very simple plan. It's when a child comes into play that things get very complicated and you really, really need to do something. When that child appears, children in Indiana may not own more than $10,000 without there being a guardianship, which is a very difficult, very expensive legal proceeding to have going on. So one of the chief things that parents want to do is, one, provide a guardian to raise their child and someone to manage the money so that the child doesn't have it in their name. It's there for their benefit, but not in their name. And that really makes things easier for those children and the people taking care of them who are left behind.
Yeah, and some of that changes state to state, right? So you're speaking specifically for Indiana when it comes to children, and then for married couples that, you know, assuming each other's, you know, estate and belongings, but every state kind of operates a little differently, right?
Correctly. We have 51 different processes in the United States. Puerto Rico being the 51st, they're much more based upon Spanish law than they are on the English common law. And so, yes, everything I say pertains to Indiana and is based upon Indiana law because my license stops at the border. Though I can help people in other states, generally find lawyers in those states and their communities who can help them with their plan. So if they're in Illinois or Iowa or Michigan and they're members, I'm happy to talk to them and tell them how to go about finding appropriate people to help them.
No, that's super helpful. And so, if one of those life events, like getting married or becoming pregnant, kind of triggers a person's need for an estate plan, what does somebody need to gather and what do they need to prepare in order to come to you for an appointment?
Sure. And I want to put out here right now is if you're my client, I don't screen my calls. You'll want to call me. And the things that I tell people to do is, first of all, make a simple list of your major assets. So, for instance, it might be your elements savings and checking account, your house, an IRA or a 401k. There are several things that get into the mix and the formula to make sure that everything gets aimed where it's supposed to go. And some plans can be exceedingly simple in the state of Indiana, and some plans are much greater. I'd also ask them if they have children, who would they want to raise their kids if something happened to both mom and dad? Who would they want to take care of the child's money, which would be a minor's trust trustee? And then we talk about alternates, and it's the alternates. Husbands and wives, for instance, usually do everything for each other. It's the alternate because generally one will die, the other will survive. And so then the alternate healthcare representative, which we'll talk about later, needs to be in place. The alternate power of attorney needs to be in place. The alternate executor needs to be in place. These become the really important people. And so I'll ask them to have talked about these things so that they have answers for me when they get there.
Absolutely. And what questions do you wish people would ask you during appointments? What do you think is most effective? I'm sure at this point in time, practicing for as long as you have, and what I know of you, you address things pretty head on. You already told us at the top of this presentation that nobody's going to get out alive. So we probably need to have a plan. So you're a pretty direct guy, which I appreciate about you. But what questions do you wish people would ask? What do they really need to know during these appointments?
Sure. When they're in their 20s, 30s, and 40s, is a different set of issues that I want to bring up with clients than, say, in the later 70s and 80s. Timing differences. When you're young and healthy, your probability of meeting an untimely end are fairly remote. But you get into your 70s and 80s, and things could happen very rapidly. So, for instance, in a power of attorney, I normally, for a younger person, wouldn't have that power of attorney be in process, be effective right then. I would take a triggering event like your physician saying, you've had a stroke, you're unconscious, you can't take care of your affairs. Up in the later 70s and 80s, the chances of being incapacitated and needing someone to help you with their finances is right there in your face. And you need to appoint somebody that's effective immediately and able to help you. And that power of attorney is a powerful position and one in which I'll wish people ask me, what are the characteristics of an effective attorney? In fact, is the person you appoint. What are effective traits that they have? What do they need to know? Those are the things I wish they had asked more about because I've watched so many ineffective appointments that I know the opposite. And that's not what you want. But here are things that are good traits.
Yeah, absolutely. And that kind of leads us into our next topic. So now that we know the triggering events of when we need to think about having an estate plan prepared, we know what we need to gather before appointments. We have our list of assets, and we've kind of given some thought about the people in our lives that we feel are in a good position to help make decisions for us or for our loved ones or for our estate. How do we know where to put that? The big two that I always hear about is a will and a trust. So high level, can you explain the differences in those and when one is maybe more appropriate than the other?
Sure. And let's go out and expand it beyond just a will and a trust.
Please do.
Indiana has fortunately had a very favorable legislature, as that the lawyers, state lawyers, have gone to and asked for certain things. So, for instance, a last will and testament or a revocable trust, which are the two instruments you talked about, are just two options available to Indiana residents to do their estate plan. So we have extensive joint tenancy rights of survivorship laws, which allow two people to own an asset and that asset to pass to the survivor, or sometimes the survivors with three or four people involved, without there being any proceeding to do that. It just happens automatically as an operation of law. We have a very good, probably a nation leading transfer on death, pay on death statute, which outside of a 401k and its cousins, an IRA, life insurance, you can add that designation to any asset in Indiana, which will cause it also to pass at your death without there being any estate administration or trust administration. So that, there's another method that Indiana gives us to do things. So those are all kinds of options on the table to be explored. Now, the difference between a will and a trust: a will only covers assets that are in the decedent's name alone. For it to be, for instance, Kent Emswiller's and his estate, it had to be Kent Emswiller alone. No transfer on death, no pay on death, no joint ownership. So that's a really important distinction that most people don't understand, that your will only affects those assets. A trust is also a written document. It names a trustee to hold things. You can be your own trustee to start with. You can have assets in that trust, or you don't have to have assets in that trust. And it proceeds along until you perish, at which time the trust will have a successor trustee. Now, the biggest difference between the executor and the trustee is, in Indiana, the executor generally will be done in 3 to 5 months, handling the one name assets. The trust might go on for years and years and years. So, for instance, if you have a young child, you don't want that child to receive their inheritance at 18 or 21. They're too immature. They've not got kicked around by life enough to understand how to do that. So that trustee might be holding their assets until they're 25 or 30. So the length of time of service is the biggest difference between a trustee and an executor. And the trustee generally has no contact with the court system. And in Indiana, an executor has perhaps no contact with the court system, but at best a minimal amount. Those are the big things. Differences: revocable trusts are really good at three things better than an estate. One, if you have non-Indiana real estate, that Florida condo I see all the time. Florida is a hard place to transfer assets. If your trust owns a Florida property and you die, you died. Your trust didn't die. It just keeps chugging along with that Florida condo. If you have a child that you don't want to receive anything, disinherit that child, it's harder to break a trust in Indiana than it is a will. So you would write a revocable trust, put your assets in there, and then go on and disinherit the child. It's harder for that child to climb to the top of the mountain to break your plan if you use a trust than it is if you use a will. Lastly, if you want secrecy, Indiana's revocable trust, you can tell the trustee, don't tell the beneficiaries who the other beneficiaries are. Don't tell them what's in the trust. Don't tell them what happens when I die. So if you have two children and you're giving one of them 80% and the other 20, you might not want them to know that you're doing that. But I also add this to all the clients. You're dead. The worst thing they can do for you is come out to your gravesite and steal the flowers. So do what you want to. This is your plan. Just the fact that your family's unhappy, that's not the issue here. The issue is, are you happy in what you did?
And are there generally when it comes to executors and trustees, are these people that we know personally? Are they family members? Are they friends of the family? Are they our attorneys? But what pool should we be picking from when it comes to an executor versus a trustee?
Everybody you just named is in the pool, but I describe it this way. If the client says, what are the characteristics of a good executor or a good trustee? And I go, the number one item is they will willingly say, I don't know what I don't know. And if they're willing to say that, they're on the beginning of a good path. Because I don't expect them to have done this more than this maybe one time in their entire life. If
Right.
they know they don't know, then they can come to a lawyer and say, what do I need to do? And I go, well, we need to hire a CPA to do taxes. We need to hire a financial advisor to help us manage the money while we're in control. You need a lawyer to guide you through that. And that would be true as an executor or a trustee for all the things that they need to do. But the chief one is they recognize they need help. They are honest. They have integrity. They are willing to say the word no to relatives who want to change your plan after you're gone and don't have any right to do that. They need to be told, I'm sorry, I'm the executor. I'm going to do what I'm supposed to do, not what you want me to do.
Absolutely. And that leads us into something that you touched on before, but when it comes to healthcare, end of life decisions, and guardian appointments. So we also need to be really choosy about the people that we're putting into those positions for us, correct?
Absolutely. And I like to tell people sit down and have a conversation with these what I call side issue before you die type things. And let's use a healthcare representative because I consider it the most important decision an individual will make during their lifetime. A healthcare representative is a person who will make medical decisions for you when the physician decides, in his or her opinion, that you can't understand enough of what's going on to give informed consent to what they want to do. And then I'm not talking about an emergency situation, I'm talking about non emergency situations. So the physician, you've had a stroke, and the physician says, well, obviously, I can't communicate. That is when your healthcare representative comes into action and will make decisions. It is imperative that you have a conversation with this person before anything happens so that they can listen to you talk about, well, if I've had a stroke and I can't function and I'm not going to recover, I want you to pull the plug. Indiana will allow you to disconnect from mechanical means keeping you alive. But you need to tell the person that. The physician walks in that hospital room and he's going to or she's going to expect an answer fairly quickly. So you need to have painted a picture for your healthcare representative that causes them to have a memory of that conversation, which should be fairly harsh and something that they'll remember so that they can set the facts of the moment into that conversation and know what you want them to do. That's really important is that conversation. And you also need to make sure that the stakeholders in your life have heard it also as well as what to do with your remains when the end comes, because those situations are just rife for the family to disagree. And you want all the heads in the hospital room, which I define as the stakeholders, to be nodding in agreement when the person actually in power says, Doc, we choose option number two. I don't want half yes and half no. Those stakeholders need to hear it from your mouth as to what you want done.
Yeah. So what I'm hearing is if you are looking to appoint somebody in your life and you want to have these conversations, maybe set a time to have the conversation and make it an event so that it stands out in the person's head. Casually mentioning that you want to be buried on a Tuesday to your healthcare representative or the person making those end of life decisions. It's a little bit of a jump scare for the person on the receiving end, and then it may not be super well received. Again, these conversations definitely can be uncomfortable, but I appreciate what you're saying, that choosing the right person who will carry out your wishes, even when it's a little bit more difficult to do so, is really important.
Years ago, I would get that question, when do I do this? And I said, well, here's the best time on Thanksgiving Everybody will be at your house, and people tend to gather into the kitchen. So about the times the pies come out and the bird goes in is a perfect time, because that smell is going to go through the house, and they'll all come in there, kind of eyeball the pie and the turkey going in, and then you've got them. And have that conversation at that time, because they're all going to be in one place, and you only have to say it once then.
Sounds
So
memorable.
that was my good story about when I told people to have that conversation.
Yes, do so with caution.
Yes.
And then guardian appointments. So you mentioned this earlier, making sure that your children are left in the hands of individuals that you want to raise them. I can't think of something that's more important than that. So can you talk about that?
It doesn't have to be a relative. What you're looking for is someone who models parent the way you want your child raised. So that's the chief characteristic. So that guardian with you gone is going to set your educational opportunities for your child, their religious upbringing, their moral upbringing, their ability to tell right from wrong. So it's very important that you look among the people who you've encountered and choose someone who models parent the way you want it. It doesn't have to be a relative. It doesn't have to be anyone who is involved in your child's life. It just has to be someone who you believe will do a good job in raising your child when you're not there.
And do you think that that conversation should also happen ahead of time, once you've made that appointment or before you've made that appointment?
Oh, absolutely. You need to have talked to that guardian to make sure they're willing to step forward. And I also always want a alternate behind that first name guardian, in case that they look forward and they go, I don't see myself doing this for 18 or 20 years. I think I'll pass, because they don't
Mhm.
have to accept. So you always want to make sure you have a backup, particularly for that position, and also the trustee watching your child's money, because they're going to be around for 20 or 30 years having to do that. So those are things that you need backups for.
Absolutely. Well, what I've gathered through this conversation and working with you for many years now is that this isn't something that you need to do alone. So, as an attorney, you're going to help them walk through these steps of maybe a foreign process or an uncomfortable process, and you'll be there either for them or for the trustees that they appoint. So, I feel like that's comforting to know that you've been through the process many times. So, you'll be there for your clients and the person involved in their estate plan.
Well, I appreciate that. And yes, for the past 46 years, that's the kind of law. And it has changed greatly in my years of practice. And I'm happy to say Indiana has done nothing except make it easier to do an estate plan. They've made it easier and cheaper when something happens to you, to make sure that your assets go to the people that you want them to go to without any interference from the state, without any inheritance tax here locally. It's just how good a plan have you put together will determine how quickly and efficiently your intended recipients receive their inheritance.
I feel that planning your estate is not just about your finances. It's about ensuring that your loved ones are cared for and that your legacy is protected the way that you wanted to protect it. By taking the time to create an estate plan with a very capable attorney like Kent, you're providing a gift of clarity and security to your family during what I'm sure is already a difficult time. We hope that today's episode has inspired you to start thinking about your estate planning journey. Remember, you're not alone again in this process. Seek out professional advice like Kent and take the necessary steps to secure your future. If our listeners are interested in working with you, Kent, how can they reach you?
Well, probably the easiest way is just to pick up the phone and call me. 317 257 8787. I believe my other contact information, like my email, is on Element's website. They can simply call. I don't screen calls. I'll be happy to talk to you. We'll get together for an hour and let's talk about estate planning. I don't charge for that initial conference, so I like talking to people, and this is something I like helping them with. So I'd be happy to talk to any of the listeners right now.
Yeah, and I can personally say I've had several members and people that I know that have worked with Ken on their family's estate plan. And something that I appreciate is he's like the least attorney that I've ever worked with. So he speaks plainly. You understand what he's saying. I've asked him, I don't know, about a million questions up to this point from working together. And he's always been really gracious, and he's never made me feel dumb for having the questions that I do. Because this is not what I do all day, every day. It is what he does all day, every day. And I think that he has a passion in helping people understand what's best for them and what's best for their families, and marrying that to the current laws in place to help them get where they want to go. And then also, I believe that there's transparency in what Kent charges for his services. So I appreciate that because that is a thought process that comes up. Is this affordable for me? Is this something that my family can do right now? So thanks for letting us know that initial conversation will absolutely not have any charge. And then he's very transparent moving forward if there's going to be a charge involved. At Elements, we'd also like to remind you to make sure that you've updated your bank accounts, either with us or with your primary institution, to have correct beneficiaries, to simplify the process and how things transfer. And then if you have any further questions, please feel free to reach out to us at elements.org. And for more helpful advice, check out elements.org/advice. And thank you for joining us on Better Money with Elements Financial as we chatted about estate planning. We hope you were able to take something away to help make your money better. Find more episodes at elements.org/bettermoney or anywhere you listen to podcasts. And don't forget to rate and review. As always, reach out to us at bettermoney@elements.org, and we'll see you next time.